Further hearing in the appeal, RFC 2012, formerly Rangers, and the Advocate General for Scotland.
Mr. Abbott.
My Lords, my Lady, I'd mentioned briefly towards the end of yesterday about the position of trustees being invited to make loans to the employees of these trusts, and I just wanted to draw your Lordships and my Lady's attention to some of the evidence and findings in the first tier tribunal about this. If I could invite you to look at page 269, or this is MS number 269. This is part of the majority decision in the first tier tribunal.
Yes.
And the paragraph 44, which is right at the bottom of that page, and then it goes over, and it talks about Mrs. Orchard's evidence, who's a director of Trident, which is the second trustee company.
Yep.
She explained that Trident had to date taken over the administration of most of the Murray Trust from the previous administrative trustee, Equity. Equity is the same company as Insinger, which was the original trustee. She understood that the Murray Group had become dissatisfied with Equity's hesitation in certain cases to advance unsecured loans to the recommended, quote, beneficiaries, unquote, out of the relative trust's funds. She explained that Trident was prepared to be more amenable to such requests. It was satisfied, she indicated, by the current employment circumstances of the borrowers, vouched in very general terms by the group. And then if I can invite you to go forward to MS 284, this is part of a number of sub-paragraphs of findings by the tribunal.
Yep.
And it's number 10, Roman 10. It's about a third of the way down page 284. In July 2006, the original trustee of the principal...
Sorry, which page?
284.
284. I do beg your pardon. Thank you. I have 10. Yes, thank you.
It's 118.
Yes, yes.
118,
Thank you.
big numbers. In July 2006, the original trustee of the principal trust, Equity Trust Jersey Limited, known earlier as Insinger Trust Company Limited, was succeeded by Trident Trust Company Limited. Each trustee was resident in Jersey. Sub-trusts set up before that date had also been administered, thank you, by Equity. Certain of these were also transferred to Trident then. The new appointment made by MGML was prompted by several instances when Equity had questioned certain loan applications which had delayed payment. So you can see there that it looks as if the Equity had had difficulty justifying to itself the making of some of these loans, and as a result they'd been replaced. Now, if that had involved, shall we say, one of the employees or protectors replacing a trustee, the reason for that was because of the difficulties in making these loans, which had come under question. And so I'm not suggesting that the power to appoint trustees was wrongly exercised, or even that it wasn't a fiduciary power in the normal way. What I do ask is for you to consider whose interests were being considered by an employee when changing the trust. Really only his own. It's in order to make sure that these loans continued in this way.
Sorry, I mean, I'm not with you. I mean, those are very thin strands to hang that proposition on. I mean, all we know is that they decided they wanted to replace the trustees because they'd had difficulties over a couple of instances.
Yes, well, I hesitate to say this, but in the fact-finding in the minority decision in the first tribunal does take the matter a bit further and explains what the difficulties were.
I mean, we're stuck with the facts found by the majority.
Yes. Well, we can't
sort of
No, oh no, I'm not suggesting that. It's just the account of the evidence is a bit fuller. Anyway, that's all I want to say about that. That there's no evidence that the change of trusteeship was because of the interests of the beneficiaries, and I'll come to the question of who the beneficiaries were in a moment. Anyway, I said that I would then take you to look at...
I mean, you're trying to show that this was completely under the control of the employee, aren't you? And how
No, I don't go that far.
how far do you need to go? I'm not quite clear.
Well, the point is about the power of amendment
Yes.
and the question of how far that goes. So far as the control of the trust is concerned, that is very important. The power of amendment is crucial to our case. But so far, when the trust is running in the normal way, all it's doing is holding the benefit of this loan which has been made. So the trustees don't actually have to do anything. It's been, no doubt, quite carefully designed to make sure that they don't have to do anything. If they did, they would probably be putting in more expensive fee claims, but who knows. But so while it's running, there's nothing to do. There is a loan, the employee has the benefit of it, and that's fine. What I'm aiming to look at is the power of amendment, but in order to do that...
To show what?
To show that the employee had unreserved control of this money.
Unqualified control and unqualified ability to amend.
To
amend?
Yes.
Yeah, so you've got to show it's unqualified.
Well, unqualified in the sense that it is capable of adding himself as a beneficiary. I mean, that's the important thing, really, that our case is based on. And in order to do that, I mean, we're always told that we should look not at individual clauses, but at the whole document, and that's what I'm doing now. So if I can ask your lordships and my lady to look at first of all, at the text of the principal trust, which is at MS 486. And to cut a long story short, there's nothing very strange in this particular trust, in the principal trust, but there are a few provisions I want to just show you. And the first one really is at page 489. And clause 1.1.4, which is the definition of the beneficiaries. And this is a wide group of people, present, past and future employees from time to time of the founder. And if you glance at the previous page, you'll find that that is Murray Group Management Limited. And, going on, and the wives, husbands, widows, widowers, children, stepchildren and remoter issue of such employees, and the spouses and former spouses, whether or not remarried, of such children and remoter issue. Beneficiary has a corresponding meaning, provided that no excluded person shall be a beneficiary. Excluded persons are then defined as people in Schedule 2, and Schedule 2 appears at page 501, and that is people who are all connected with the founder, basically. It's the founder, any person connected with the founder, participator in the founder, person connected with any participator, and anyone who is or becomes and then there's a provision about ceasing to be an excluded person when the connection is broken. So all of that about excluded persons is to do with connections with the founder. And then moving on to, if you glance at some of these provisions, you'll see many of them are repeated in one form or another in the subtrusts. But what I want to do now is just look quickly at clause 2.1, which is at page 490. And this is the declaration of trust. There's a heading there, and you'll see, subject, as aforesaid, subject to clause 10, the trustees shall, during the trust period, hold the trust fund upon trust to apply the income and capital thereof to or for the benefit of all or any one or more, exclusively of the others or other of the beneficiaries, in such shares and in such manner generally as the trustees shall at what discretion think fit. Pausing there, that is a classic discretionary trust of income and capital. And then there's a proviso that they may, in their absolute discretion, think fit, accumulate the whole or any part of the income of the trust fund. And so that applies throughout the 80-year trust period, which is defined somewhere. It's on page 489, 1.1.3. Looking further, page 491, clause 4, has a duty to exhaust capital and income, it's not very common, but there's nothing wrong with it. I draw attention to it only because it's repeated in the subtrusts. And then clause 9, the power of amendment. And you'll find that this too is repeated in various ways. But in this instance, in page 493, subject to clauses 9.2 and 10 hereof, the founder shall, with the consent in writing of the trustees, have the power at any time by deed to alter or add to all or any of the provisions of this deed in any respect. So it's a very wide power of amendment. And then there are restrictions. The power granted by 9.1 should not be exercisable nor exercised. No, this is 9.2. To alter any of the provisions of 3.3 above. Now, going back to that, what is that? This is the firm. This is an entitlement of the firm to insure its service fee, and the firm is Baxendale Walker. So that's a protection for Baxendale Walker. And then...
What's the effect of clause 9.2?
9.2, well, it's the sub-clauses that apply. It says you can't be exercisable in any of the ways in 1, 2, 3, 4, 5.
Just those, yes. Okay,
yes.
thank you.
So one is 3.3, then you're not allowed to alter any of the provisions of 10.1 or 10.2 or 10.3, or to alter the definition of excluded persons, which you've seen, and 10.1 and 2, clause 10 is about prohibited benefits. These are essentially pension benefits. 10.2 10.2 is a restriction so that payments can only be allowed if they lead to deductibility for tax purposes, essentially. That would have constituted an expense incurred wholly and exclusively for the purposes of the trade of the founder. And then 10.3 is about prohibited investments, which again is connected with the founder. So that's the text of the principal deed. Then moving...
What are we looking for in this? I mean,
Sorry?
So far, nothing very
No. And
tell us when we're looking for something interesting.
I will indeed, my lord. Could I take you briefly, before doing that, to 502, which is the beginning of a deed of adherence, by which the Rangers Football Club Plc was added as an adhering company. And it's quite a short deed. The operative bits are pages 503 and 504, and it recites that they want to amend the deed to achieve this result. And then the operative provision in clause 1 is the founder, in exercise of the power contained in clause 9 of the trust deed, hereby agrees that the adhering company be permitted to adhere to the trusts of the scheme with effect from the date of this deed for the benefit of the adhering company's trade, so that the past, present, and future employees of the adhering company become beneficiaries of the scheme, as defined in clause 1.1.4 of the trust deed. And then the trustees consent to that. Adhering company undertakes to adhere to the trusts, and then 4 says it's subject to English law. Now, this is not a criticism, but I do draw attention to the fact that the beneficiaries for an adhering company are the employees, past, present, and future. It does not include their wives, husbands, children, stepchildren, grandchildren, and so on, who are mentioned for the employees of the founder in the principal deed. So essentially it focuses on the employees, past, present, and future. Now, I now want to go to the subtrust, and for this, the Inner House have mentioned the trusts of Mr. Martin Bain, and so if I can ask you to do the same and go forward to page 548. And this is a declaration of trust by Insinger de Beaufort Trust Company Limited, which at that time was the trustee of the principal deed, later became equity trust, and was subsequently replaced. Now, here, and this is where I describe this trust as strange, and I want to make that good. First of all, it's a declaration by a trustee, presumably of its own £100, but that doesn't really matter. The important thing would be about the addition of money from the principal trust to this. But the point is, I think I mentioned it to you yesterday, that this is a device very often found where you don't really want to show who the settlor is if it's an individual. Anyway, it doesn't state who the individual is there as a settlor. It doesn't state that the declaration is made in exercise of any particular power. It is just a declaration of trust by Insinger de Beaufort. Then, looking at the technical parts in the interpretation, there are standard form definitions of trustee, trust fund, trust period. Of course, it has to be the one established by the principal scheme, as it's called, which means the original principal deed. Nothing wrong with that. Then you get to the principal beneficiaries. Now, this is quite important. It means the wife, Susan Margaret Bain, and children, Jack Ronald Bain and Luke Edward Bain, of Martin Bain, who shall be living at his death, provided that no excluded person shall be a principal beneficiary, and other expressions used in this deed, which are defined in the deed establishing the principal scheme, shall have the corresponding meanings in this deed. Now, I make some comments. First of all, these people, although they are close to Martin Bain, are not beneficiaries of the original scheme with the deed of adherence. An oddity, you may say. They only become principal beneficiaries, those of them that are living at Mr. Bain's death. Another curiosity, perhaps. Then we move on to...
You say curiosity. What are you asking us actually to make of it, rather than find it curious?
Well, one of the things I want to submit is that this trust deed it's like smoke and mirrors. A lot of it is designed to look like one thing. I suggest it is designed to do this because this is its effect, but actually to be another. Ultimately, what I'm going to submit is the power of amendment is not a fiduciary power in the full sense of the term. It's described as a fiduciary power without saying whether it's in the full sense of the term, but you'll see that the word fiduciary is used in this document almost indiscriminately. And what I'm aiming to show is that this is a document where some of the technical features of it would be unwise in my submission to take them too literally. You'll see what I mean as I go through the document.
Is this saying it's a sham, or are you saying we should interpret it differently? And I mean, if it's a sham and we shouldn't give it the effect that it naturally has, can we do that on the basis of being an appellate court?
It's not a question of whether it's a sham. We're not suggesting it's a sham.
Right. So what are you suggesting?
We're suggesting it needs to be construed in a realistic way.
I see. Okay, thank you.
There are then things about prohibited investments and so on, which are, again, to do with the founder. You'll see it's nothing to do with the Rangers company. And then you have the protector. Okay, the protector means Martin Bain, gives his address, or such other person as the hereinbefore named may in writing appoint. So it's Mr. Bain, and then he has the power, personally, to appoint a successor. He's called the protector, but again, I repeat my warning not to take names too literally, and you may think while I'm performing this function to think, who is he protecting? And if he holds fiduciary relations with somebody, you might like to think, with whom? Then there's the firm, which is Baxendale Walker, service fees relating to Baxendale Walker. Then there's the declaration of trust, that's the heading of it, and I must confess that I misread this as well, and we put in our case that this is a discretionary trust of income and capital. And I suggest that that may well be what the draftsman intended the reader to think. And it's what the inner house thought. And as far as I can tell, it's what every court has thought so far. But as you'll see, it isn't. It's a power of appointment. Subject as aforesaid, subject to clause 10, the trustee shall, during the trust period, hold the trust fund and the income thereof upon trust for all or any one or more, exclusively of the others or other of the principal beneficiaries, in such shares and in such manner and under such trusts and subject to such powers and provisions, as the trustee shall in its absolute discretion during the trust period by any deed or deeds revocable or irrevocable appoint, as the trustee shall in its absolute discretion think fit. So that little bit's repeated about the discretion, provided that, and then there's this power to accumulate income. And if you start looking for any other declaration of trust of income and capital to be applied during the trust period, in default of any exercise of that power of appointment, I'm afraid we are looking in vain. There is no trust. That's another curiosity of this deed. And the fact that, as far as I can see, all the courts below, well, and I, but including the inner house, thought that this was the basic discretionary trust of this trust is a mistake, if I can put it like that. One of the reasons that they relied on was, well, because you'll come to the power of amendment. The power of amendment says that you can't change 2.1. And the inner house said, well, of course, if you can't change 2.1, you certainly can't change the definition of principal beneficiaries, because it's implicit in 2.1 that that is so, because it's the basic discretionary trust of this trust. Well, what I'm submitting to you is that it isn't.
Yes, I see.
Moving on to 2.2, this is another curious provision. The trustee may, during the trust period, with the consent of the protector, declare that the class of principal beneficiaries has ceased to have any members, whereupon the trust fund shall, from the date of such declaration, be held upon the trusts of the principal scheme. Now, in some ways, on the face of it, that looks like a discretionary power for the trustees with the consent of the protector. Quite typical, you might think. But it's worth thinking how that could possibly be exercised. It's inconceivable that that would be construed as meaning that the trustee could declare the class to have ceased to have any members unless it actually had. To imagine a circumstance where there really are principal beneficiaries in existence, and the trustee putting its hand on its corporate heart and saying it ceased to have any members, and getting the consent of the protector, that's inconceivable in my submission. So what it's talking about is a circumstance where there aren't any members. They have all, as it happens, predeceased the employee. All right, well, what is the consent of the protector for in that circumstance? And what I submit is that it's rather a telling requirement for the consent of the protector. You have no principal beneficiaries. The consent of the protector, well, he's protecting his own interest because, of course, the loan, one can imagine, might still be outstanding. And he would want to make sure that the trust can continue, which he could do in our submission, but contrary to the view of the inner house, he could do it by adding principal beneficiaries in the exercise of the power of amendment. Now, Clause 2.3 is a power to transfer the trust fund to other settlements.
Yeah.
Then there's Clause 3, the exercise of the trustees' powers. And this is again rather interesting, because, only in a mild way, I suppose. It says that the trustee can exercise powers and discretions, notwithstanding that he is one of the trustees. Yeah. So long as at least one of the trustees is neither a principal beneficiary. So this is a provision that is much more appropriate to a personal trusteeship, not really to a corporate trusteeship. And then similarly, a provision about being a director of a corporate trustee, notwithstanding that the trustee is a director of a corporate trustee. It doesn't really make sense. It looks like a fairly common form clause, but it's not really very appropriate. Then 3.3, and this again comes back to my smoke and mirrors. The firm, that's Baxendale Walker, shall have the exclusive power, which shall be a fiduciary power, to authorise, instruct and oblige the trustee from time to time to discharge any invoice in respect of any service fee, and it's how it's exercised by notice in writing and so on. So that's fiduciary. Well, in what sense could it be fiduciary? Well, it has occurred to me that it might have meant that the firm has to exercise it in the interests of the members of the firm. But the idea of it being fiduciary in the sense of being, the Baxendale Walker being loyal to the principal beneficiaries, or some of them, doesn't really make sense. So that's what I mean by the word fiduciary in this document being used in a somewhat
Yes, I see.
non-discriminatory way. Then there's Clause 4. I don't need to look at it particularly. It's the duty to exhaust capital and income. That's repeated from the main trust. Further trustee powers in the schedule, limitation on the trustee liabilities, not incidentally any limitation on the protector's liabilities. The appointment and removal and resignation of trustees, well, this is, I've already mentioned this really, but it's a power to do that, remove and appoint new trustees. We have accepted that it is fiduciary. Whether that's in the full sense of the word is perhaps another question, but we're not pressing that point. Then there's the governing law, including a power to change the proper law. Then there's the power of amendment, and this again has a lot of the similar features to the one in the principal deed, but it's not identical. Subject to 9.2 and 10, well, I don't need to look very far there except to look at what is in 9.2. The protector shall have the fiduciary power to, at any time, by deed, to alter or add to all or any of the provisions hereof in any respect, provided that the foregoing power shall not, without the consent in writing of the trustee, be exercisable in any manner which would adversely affect the trustee. I'll come back to that proviso in a minute. Then 9.2 prohibits various alterations. One is Clause 2. I think I've mentioned. That's what now is revealed as the power of appointment. Then 3.3, that's the one that protects Baxendale Walker. Then any of the provisions in 10 or 10.1 or 10.2, which are all to do with protecting the founder's position. And then 9.2.5 is about excluded persons, which again are people connected with the founder in one way or another. So the only important ones are the one about Clause 2 and the proviso to 9.1.
Yeah.
Now, in regard to the proviso to 9.1, we have in our written case, paragraph 113, answered a potential criticism that comes from my learned friends that there is an important restriction which essentially prevents the protector or the employee from having an unrestricted power, and that is answered in paragraph 113 in two ways. I think the point they take is that if the employee were to exercise this power to make himself absolutely entitled, he would then trigger a tax charge. And the trustee would be liable for that tax charge and would have to indemnify the founder. I think it's the founder or the employing company that would be liable for the tax charge. Then the trustee would have to indemnify it, and that is a disadvantage to the trustee. And the answer to that is shown in paragraph 113 in our case. And essentially there are 2 points. One is that it's not the exercise of the power of amendment which gives rise to the tax charge. It's the existence of the ability of the employee to terminate this trust, which makes him unreservedly entitled to the asset, to have unreserved control. And so it's the existence of the powers to terminate the trust, if that's what they are, as we submit they are, which gives rise to the liability, not the actual payment. And the second reason is, whether we're right or wrong about that, when trustees are liable for a charge to tax, they have a lien on the trust assets to provide indemnification for that liability. And even if that fails because they can't get hold of the assets, there is a personal indemnification. If a trustee finds itself a bare trustee for an individual, then there is that Privy Council authority which says that in those circumstances they have a personal right of indemnification.
Yep.
So I may say that what I've been doing in these last few minutes is really more or less paralleled in our written case in pages 137 to 140, and that has a lot of the references. The one reference that it doesn't have, the one is in the middle of page 138. There's a reference to part of the first tier tribunal decision. In fact, that's a part of the same paragraph that I read to earlier, and the MS number of that is 283.
Thank you. Yep. Yep.
And so, having seen what there is there, it's also interesting to see what's not there, and I've emphasized there are no beneficial trusts of income and capital. There is also no indemnification for the protector of the kind that might be expected if he were expected to exercise fiduciary powers in the full sense of the term. And what I'm saying is that many of the provisions of this subtrust seem to be saying one thing but doing another. There is a class of principal beneficiaries defined, but in a way it's an empty set. It's only people who are living at the employee's death, and in any case, all they are is objects of a power of appointment. The protector has power to give or withhold consent to the exercise of the power in 2.2, but on examination, as I've said, by definition, there is no beneficiary being protected there. So to call him a protector is, we suggest, somewhat fanciful. He's protecting nobody but himself.
Yeah.
Or you could say he's protecting a beneficiary to be added by a future exercise of his power of amendment. Some powers are described as fiduciary, but I ask rhetorically, in what sense, and in whose favour is their loyalty to be shown? Well, I've, I think, identified what the powers of the protector are. The only one of any importance in this appeal is the power to amend, and in regard to that, it is capable of being a dispositive power. It's not limited to administrative provisions. In this instance, it's called fiduciary, but that word is used indiscriminately in the deed. It describes the Baxendale.
I mean, arguably, whatever else it means, it doesn't suggest that he can simply appoint himself.
Well, I'm coming to that. It means it's fiduciary, but in what sense? Is it a Category 1 fiduciary
I mean,
power?
forget about that.
Well,
If one's got to give it any meaning, one would have thought the one meaning one might give it is that it doesn't mean that he can favour himself.
you might, if it was the only provision in this deed which had to be considered. But in our submission, it isn't. It is right to think of this in terms of this very curious document.
I mean, you're saying it's meaningless, really.
No, I'm saying that he's using it in a way that may be intended to show one thing, but actually it doesn't mean that. Fiduciary, as I pointed out yesterday, can have...
Yeah, but what do you say it does mean, then?
What do I say?
What do you say it does mean?
It means it's a Category 1 fiduciary power.
Meaning,
It's a power exercisable by a single individual which can be released. It's not a fiduciary power in the full sense of the term. That will be a Category 2 power. And that there is no reason, and I'll show you a case where this happened, there is no reason to suppose that it can't be exercised in favour of himself. And that would be so even if it were a Category 2 power, but we suggest it isn't. So going on, it's in Mr. Bain's case, the power is exercisable by himself. And unlike the case of Metoy, you may remember what I said about Metoy, there the company was the beneficiary in default of appointment. And there, Mr. Justice Warner decided that a power of this kind, fairly unlimited power of amendment, was a fiduciary power in the full sense of the term. This is not like that, because the employee is not a beneficiary, surprisingly, of the subtrust. You may say he should be, because he was the one person for whose benefit this trust was established. And he was the one who was a beneficiary after the deed of adherence. But he's not, on the face of it, a beneficiary at the moment. And he's not the beneficiary in default of appointment, for instance, of the power of appointment. So this is not a power exercisable by trustees or by a body of persons looking like trustees. It's exercisable by a person who's given the title protector, and it's described as fiduciary, but then other powers are described as fiduciary, or one other power is described as fiduciary as well. I may say that not all of the subtrusts do call it fiduciary. Not all of the trusts call the employee the protector. Sometimes they just call him the employee. Sometimes they call him the provider. But in this one we're looking at, he's called the protector. But even so, in my submission, that does not prevent him exercising this power. And the next point is that he is connected to the potential beneficiaries, partly as a recipient of the loan. The loan is the guiding purpose of this setup, and he's the recipient of it. But he's also a relative of the existing and potential beneficiaries after his death. Unlike a typical protector, if you think back at the typical case that I showed you yesterday, with a raft of dispositive and administrative powers conferred on trustees, subject to the consent of the protector. This is nothing like that. I may say also, he selected these beneficiaries. And you'll remember that part of the purpose of this trust is to provide a deduction for inheritance tax purposes at his death. So you imagine looking at that prospect, he's got really to make sure that the beneficiaries he wants to benefit at his death are the same as the ones who benefit under this trust. Otherwise, there's going to be a mismatch. He wants to try and achieve a result that it doesn't really matter to them whether they collect this loan back or not. And so it's in a way testamentary, this document, or should be. And that is emphasized perhaps or supported by the fact that the beneficiaries are those living at his death. They're defined in that way. And so it would be very surprising if he couldn't change those beneficiaries during his lifetime. And there's a passage in our written case which deals with this at a bit greater length. This is in paragraph 115 at pages 142 and 143.
Yeah.
And I've made the point that it must have been obvious to the draftsman and to his clients and the employee himself that changes might well be needed. For example, if he had a further child, he would expect that child to be included, or he would want that such a child to be included. Less agreeably, if there were a divorce, with or without a later remarriage, that would have been another occasion to want a change. And a court of construction shouldn't assume that a draftsman and his clients would have wished to prevent such amendments. And I invited your lordships and my lady to put themselves in the position of somebody drafting these trusts yesterday. What I would now like to do is to ask you to put yourselves in the position of a judge of the family court faced with this trust in the context of an application for financial provision. Are we saying, I don't want to go into whether this is a post-nuptial settlement or not, but are we really supposing that this trust would be beyond the reach of the employee? Anyway, those are the features of this trust, and before drawing conclusions about the nature of the power of amendment, which is the important thing, I wonder if I could show you very briefly, will have to be very briefly.
Can I just ask Mr. Herbert, so
Yes.
So just to make sure I've understood this, you're really saying, if I've followed this, that in the clause 114, identifying what are called the principal beneficiaries, what are actually identified are a class of potential beneficiaries, and in 2.1, the so-called declaration of trust, the effect of that is that there is, do I understand this, there is in reality no trust unless and until the power of appointment is exercised.
Yes.
Were there any findings of fact in the tribunal as to whether or not powers of appointment were exercised? And if there weren't, can we assume that they were not?
I don't think there were, and I'm not relying on any of them, nor am I concerned to do so. There were cases, there was at least one case that I read about, I think it was Mr. Kloss, who did exercise the power of amendment to bring his wife as a beneficiary, as a principal beneficiary of his trust.
To what extent is it appropriate if we're construing this, and I understand this is really an argument based on interpretation,
Yes.
to bear in mind that if it has the effect you argue for, then it would be an unreserved disposal, which is clearly not what was intended, because the whole purpose of this was to avoid tax.
The whole purpose, I suggest, is to make it look as if he doesn't have unreserved disposal.
No, the whole purpose is to avoid tax. Whether it succeeds or not is a matter of law, but isn't it a bit counterintuitive to be straining to construe it in such a way as it does not achieve that which it plainly was aimed at achieving?
Perhaps, but I'm not defending the draftsman of this trust.
No, I'm not defending him. I'm just saying for her. I'm simply saying how does one approach the question of interpretation? I can see you can say it's not for the court to assist people to avoid tax, and that's a fair point, but it's not quite the way I'm putting it. If we're looking at what was intended.
Well, it depends. Actual intention, I suggest we should put out of the question.
Oh yes, actual intention.
Because
but
we don't have...
Given that we know self-evident what the purpose is, it's a bit odd to be straining to construe it, say it doesn't achieve that purpose.
Well, maybe it is, but I suggest that would be the right way to look at this, and it is about this power of amendment. That's all. That's the only case we put.
Thank you.
I'm still unclear what you're actually saying about the power of amendment.
Well, I haven't quite got
You haven't
my
got-
submissions about that.
Look forward with excitement.
Okay, so
Keep you on tenterhooks. Could I show you
I think Lord Hodge has a question, sorry.
Well, it really comes to this, that you say there is an unlimited power of amendment. There is no trust because there is no appointment, and therefore you can stipulate where the funds go. That's really what
You've taken the words from my mouth. Yes, yes, my lord. The existence of clause 2.2 can't be overridden, but other things can be added. And I'll come to exactly what in a minute, which is not altogether easy, I concede, but anyway, there it is. Could I just ask you to look at a case which is in volume 3 of the authorities, and it's MS 2407. The case is called In the Matter of the Z Trust. It's a decision of the Grand Court of Cayman, and therefore not authority, and I'm not relying on it in a sense. I think the law reporter will probably just put this as he mentioned the case of In the Matter of the Z Trust. And it's a decision of Mr. Justice Smellie, as he then was. And it's a very long judgment, and I'm not going to invite you to read it all, but what I will do is to explain what the basic situation was. It's a family trust. The settlor, now looking at the head note at page 247.
What are we looking for?
We're looking for the result of this case, where there was, this trust established a court of management, which included the settlor to begin with, and it also included her daughter, Mrs. D, who was a beneficiary of income, and various other members of the family. And amongst other things, the Committee of Management had a power of amendment, an apparently unlimited power of amendment, which did not say that it couldn't be used to benefit members of the committee. There was a very strong attack on this. I mean, the facts were that the committee did exercise this power of amendment to give Mrs. D half the capital of the fund. And that was attacked, and it was attacked quite strongly. And you'll see that counsel for the attacking party was none other than T. Etherton QC and a junior, and still he did not succeed in persuading Mr. Justice Smellie that this was wrong. And the result of this was that the amendment giving Mrs. D half the capital of the fund was valid. And you'll see from the head note what the way it's established. It's a trust for the benefit of the daughter, Mrs. D, who was the second defendant, and then the grandchildren and great-grandchildren, etc., were contingent beneficiaries. And then Clause 7 gave the committee power to direct investment, and under Article 4b of the trust, the management committee, together with the settlor herself, were given the power to amend the terms of the trust at any time before the death of the settlor or Mrs. D. This power was exercised to give Mrs. D a right to receive up to 50% of the trust capital, although she had previously been entitled to income only. Now, you can see, I think, with just that it was maybe a question finely balanced, whether that was a fiduciary power in the full sense of the term or not. In favour of invalidity, in other words, in favour of full sense of the term, you might say, well, the power was exercisable by a committee of management, not just a single individual. And you may remember that one of the examples of a Category 2 power in Metoi was a power exercisable by a non-trustee group of people, like the managers of a unit trust. So that's one point. Then the committee did have administrative powers, which were fiduciary in the full sense of the term, to do with investment and so forth. And there was no express provision authorising an amendment from which members might benefit. On the other side, in favour of validity, the power on the face of it was wide enough to amend beneficial provisions. It didn't say that you couldn't appoint in favour of the committee. The committee were not strangers, unlike normal protectors, you might say. They included the settlor who had selected the beneficiaries, rather like the employee in our case had selected the original beneficiaries. And one interesting point which is listed actually in the grounds for the decision is that if this were a fiduciary power in the full sense of the term, what would happen if the Committee of Management were unable to exercise it? Can one conceive of the court stepping in to exercise it itself? And you'll remember that that's one of the things that happened in Metoy, because it was a power, a fiduciary power in the full sense. And the judge found that it was not really possible to imagine the court stepping in to exercise this power. Now, if I could just take you to a passage in the judgment,
Yep.
which is a very short one, which is per page.
Which page?
Sorry, it's 2430.
Thank you, yep.
The actual paragraph is at page 2415, 4B.
Yes, that's the power.
Yep.
And it doesn't say anything about it being a fiduciary.
No.
Okay, 2430, yep.
And
Yep.
oh, I see, yes. It's the bit right at the bottom of 2430.
After the line.
Yes.
Below the line.
Below the line.
Yes.
And there's a discussion of Penrose
Yes.
about inflexible. What the analysis of the pension fund cases confirm is that while the inflexible rule of a court of equity must be observed, the facts and circumstances of settlements vary infinitely, and the intentions of a settlor are not to be readily discerned by reference only to a doctrinaire application of the decided principles. It must be a question of construction in each particular case, whether the power is given personally or whether it is given by virtue of office as being a fiduciary. Now, so that's all I'm saying, is that is an example of a case where, on the face of it, a nicely balanced question about whether this power of amendment was fiduciary was decided in favour of it not being fiduciary in the sense that it prevented anybody from benefiting under it, the members of the committee benefited under it. And so that allows me to move to the conclusions that I make. One is, this power of amendment is a Category 1 power. It is a personal power, though it's hedged about with some explicit
So the word
restrictions.
fiduciary means nothing.
Yes, it means it's a Category 1 fiduciary
I don't
power.
understand, you keep on saying that, but that's not a term of art.
Well, you remember...
You see the word fiduciary, which implies a duty to someone of some kind.
Oh, yes, it does. For instance,
If it's a
as
pure
I said,
personal power,
as
it's
I
not
said
even a
before,
Category 1 power.
as I said before, the doctrine of fraud on the power applies to such a power. But you'll remember that in that classification that Mr. Justice Warner
Yes.
accepted in Metoy, there were 4 different types of provision which had all been called a fiduciary power in one context or another. And what Mr. Walker, as he then was, what his analysis was that of those 4,
Yep.
only 2 of them were really fiduciary powers, Category 1 and Category 2, and only number 2 was a fiduciary power in the full sense of the term.
Yes, but he says that if he owes no duty to anyone at all, it's not a fiduciary power at all, doesn't he?
Well, you may say, and I may say, that he didn't owe much of a duty to anybody apart from himself in this case, because there are no current beneficiaries, as my Lord Reed has pointed out.
Yeah, I mean, we've got to work out what fiduciary means in this context. I'm not
Yes.
saying it's a sham,
No?
and so therefore it seems to me it must mean that he owes, it's not a purely personal power. He owes some sort of duty of some kind.
Yes.
And the most obvious thing would be that he can't just simply give it to himself. which is at least
That
one
may be
characteristic
obvious
of a
at
fiduciary
first
power.
reading, and what I'm seeking to persuade you is that would not be ultimately the right answer.
I know you are, but I mean, in the case you've shown us, it didn't say anything about it being a fiduciary power, and it was held to be a personal power. Fine,
what?
but it doesn't help us.
As I also said at the beginning, that it would be wrong for a court to be blinded by the use of words in this document, like protector or fiduciary. The important thing is to see what the power actually does, what it permits on the face of it as a matter of construction, who is exercising it, and in what context. And so far as its wording is concerned, it's unlimited except for the express restrictions. The inner house has said, well, you can't imagine it changing 2.1 without, but allowing the amendment of principal beneficiaries, but actually, because that would be changing the basic trust. But actually, there isn't a basic trust, as I've tried to expound.
Yes, but if there were principal beneficiaries, if there had been a power of appointment, what then?
Well, there is a power of appointment, but it's only exercised in
No,
favour
an
of future
exercise
people.
power of appointment.
An exercise.
Let's say that there were beneficiaries, the trustees owed duties. What was the position then of the protector?
Then the restriction on clause 2.1 would apply.
Yes. And there are no findings of fact, because the matter was never focused below whether or not powers of appointment were exercised.
I don't think I'm in a position to answer that, but I'm quite prepared to believe that.
Yes.
So, I revert quickly to my conclusions. It's a Category 1 power. On the face of it, it's wide enough to include the amendment of beneficial provisions, not just administrative ones. Our written case contains reasons for that. He does have a personal interest in keeping the trust going without having the trustee call in the loan. That is what he's protecting. There is no explicit restriction against appointing himself. All there is the one that I've mentioned to my Lord Hodge. Our case is essentially no different from the Re-Z trust, even a bit stronger, you might say, because our employee is a single individual, not a committee of management. And even if it is a fiduciary power, even in the full sense of the term, there is no absolute bar on benefiting himself. And we refer in our written case to the Edge case, which I don't really have time to expand
Mr.
here,
Justice
but that's
Scott,
there.
yeah.
I think he
It's-
was
it's in the
Vice-Chancellor
bundle,
at the
yeah.
time, and
Right.
the Court of Appeal, yes. And finally, I think I need to explain how the employee would actually achieve the termination of this trust. And it's not entirely simple. Nothing is with this strange trust. But what the employee could do without amending Clause 2 is irrevocably and exhaustively to exercise the power of amendment by making two amendments. First of all, substituting himself alone for the other principal beneficiaries. Second, by inserting a trust of capital in default of exercise of the power of appointment in favour of himself absolutely. At that point, he would be the sole beneficiary, without possibility of any future beneficiary coming into existence, and he could therefore terminate the power of accumulation. That is actually what the famous decision in Saunders and Vautier actually decided, that if you have a single beneficiary with a power of accumulation, he can terminate it. It's been taken much further than that, but that's what it was about. He would then be the borrower and beneficially entitled absolutely to the benefit of the loan. Having said that, what we say is the trust assets are unreservedly at his disposal. Looking at the opinion of the inner house, I'm not going to spend a great deal of time doing this, but looking at the opinion of the inner house on this part of the case, we would summarize the conclusions they reached in the form of a kind of syllogism. First of all, the employee was appointed as protector. Second, protectors are fiduciaries. Third, powers conferred on fiduciaries are fiduciary. 4, a fiduciary power cannot be exercised in favour of the person exercising it. 5, therefore, the employee cannot benefit himself. As we have already sought to argue, many of the steps in that syllogism are either incorrect or overstated, or they need to be qualified. Whether a person is a fiduciary, even if that shorthand is permitted, you remember, it's not a question of a person being a fiduciary, it's a question of what powers he has and in what sense they are fiduciary to whom they are owed. It depends on the relationship which is created by the trust as a whole and the powers and duties conferred on him. Not all powers and duties conferred on a fiduciary are fiduciary powers. Not all obligations owed by a fiduciary to his beneficiaries are fiduciary obligations. I hope I don't need to make that good, but the duties about investment are nothing to do with fiduciary, they're to do with tortious liability. Some fiduciary powers can be exercised in favour of the person exercising them. And as I say, it may be pointless to pick at the conclusions of the inner house opinion, to the extent that it describes the general law of protectors in the typical case. We don't have any quarrel with it. But it fails to recognise the very special features of these trusts. Essentially, we submit the power of amendment was apt to amend the definition of beneficiaries. There's no exclusion of an amendment to benefit himself. The power of amendment is not a fiduciary power in the full sense of the term, but a Category 1 power, rather like the one in Re Z, capable of being exercised for the personal benefit of the employee. And to the extent that the inner house failed to give justice to those features, we say with respect that the opinion was on this point in error. Unless I can help your lordships and my lady further.
Thank you very much indeed. Thank you, Mr. Herbert. Mr. Gage.
I'm so sorry. If you excuse me just for 1 second, I'll get my apologies. My lords, my lady, please, may I get the PAYE regime just out of the way, and then I'll deal with the benefits in kind with the court's permission as the last of my submissions, if that pleases the court. PAYE, please, may I make 2 preliminary points in the facts. 1, if I might ask the court, please to recollect that for the footballers, the payments into the trust and the payments of salary were component parts of a single remuneration package on the basis of which they were recruited. The court has the references from yesterday. That is uncontroversial. And the reason I make that point is that when I look at the PAYE regime, it changes slightly, but in an important way between the years up to 2003 and then thereafter. But if you'd asked a footballer, Mr. McCann, for instance, were you paid? He'd say, yes, I was paid, once through my salary and once with the money into the trust. Equally, the executives who were told the money paid by way of discretionary bonus to you, instead to avoid tax, were paid into the scheme, would you ask the executive, after the scheme was implemented, were you paid? He'd say, yes, of course, I was paid through the trust. And just to make that good, please, if the court looks at page 413 of the appendix.
Yep.
MS 579.
Sorry, MS.
579.
Thank you. Yep.
This is an email from Mr. Bain, it's him again, to Mr. McClelland. And it's the paragraph in bold headed late November. Does the court see that?
Yes.
And he's complaining. He's saying, I'm advised by Pamela she could not put my salary increase through the trust as advised by Ian Macmillan, and then so on and so forth. And then towards the bottom, he's complaining about the trust paperwork has not been processed. And then over the page, on page 414, MS 580, put short, he's complaining that the scheme was supposed to be a saving to the company, but he's losing 6,000, he considers, of salary because it's not been put through the trust. And at page 416, MS 582, again, this is phrase of the bonus being put through as a discretionary bonus through the scheme. Now, the reason I'm drawing the court's attention to this is because it forms critical background not just to the submissions I made as to the chargeability on all of our submissions, but on the chargeability on the diversion of earnings submissions, but also it informs the application of the PAYE regulations. And I'll show the court those now, please. Starting with the pre-2003 regime, Section 203A of the Taxes Act 1988, behind tab 5 of the Authorities Bundle number 1, MS 1225.
Thank you. Yep. Yep. Yep.
This replicates Section 202B, which talks about receipt meaning payment and at what time that is. For PAYE purposes, you're told what payment means, and it sets out rules, as I say, which replicates 202B. That's 203A. 203B talks about payments by an intermediary. If the court has that, and it's MS 1227. And put short, if a payment is made or on account of assessable income by an intermediary, put short is the employer who's fixed with the PAYE liability. Little 4 tells you what an intermediary is. Little a, someone acting on behalf of the employer, or little b, by trustees holding property for any persons, who includes the employee. Well, that's the principal trust in any view. I think in our submission, it's the principal trust is within little a as well, because it was discharging as part of a tax scheme the employer's constructive obligations. You saw that in the board minutes yesterday.
So we're talking about the first alternative argument now, the payment by the trust.
Well, this would also be irrelevant Yes, the first alternative, but also the second alternative, if the payment by main trust trustee to sub-trust was at the unreserved disposal. That's also a payment by an
As
intermediary.
far as the principal argument is concerned, you're talking about the payment to the trust.
Exactly.
Yes, you don't have to worry about the intermediary for that argument.
Exactly right.
That's simply rely on payment.
Exactly.
So that's 203A, little a.
Exactly.
And so you don't need to worry about little b entitlement.
A little bit about what?
203A, little b is about becoming entitled,
Exactly.
which there might be an argument about here, but you don't worry because you say it's payment.
Yes, and my response is, well, even if I did care about entitled, a person is entitled, albeit not the employee.
Okay.
Then we get to the regs. That's behind divider 13. This is the 1993 regulations. And MS, please, 1609. Definition, I'm sorry, does the court have it? Definition of employee means any person in receipt of emoluments. Definition of employer means any person paying emoluments. And then please may I go to Regulation 6. Now, this is the regulation that would apply to the payment by Rangers to the main trust. And it talks about, and this is the only, and the reason this is important, I'll take it short, but it's important, is that no court has looked at the wording of the PAYE regulation so far. And the last thing, if the Crown succeeds on the question of chargeability, is a squabble about whether the PAYE regulations apply or not. Now, Regulation 6.1 talks about every employer making any payment of emoluments to any employee. Now, the appellants in this case don't rely on this text, but this is a regulation I have to deal with. The definition of employer and employee, you've already seen, means that there isn't a problem under the 1993 regulations for the payment from Rangers to the main trust, if that payment is a payment of emoluments. And then dealing with the payments by an intermediary, this is the main trust to the sub-trust on the first alternative or second alternative. That's behind tab 14. Regulation 7, MS 1633. Now, this talks about notional payments, and with the court's permission, I'll take that short. That is simply a payment which the employer is treated as making if an intermediary makes the payment. That's not controversial. It's defined in Regulation 2 of these regulations, which refers back to Section 683 of the Taxes Act 1988. So, on the payment by Rangers for the pre-2003 regime, to the main trust, it's Regulation 6. On the first and second alternatives, it's the 1994 regulations, Regulation 7. And that equally applies if the court finds in favour of the respondents on the 154 benefits in kind provisions, because they are treated as emoluments. I'll show the court that. Now, things changed in 2003. The PAYE provisions, they start at section 683 of ITEPA, that is behind divider 9, MS 1322. So PAYE income means any PAYE employment income. PAYE employment income, the court will see in sub 2, is income which consists of section 10 taxable earnings.
Yes.
Over the page, the enabling provision for the PAYE regulations, section 684, MS 1324. And just while I'm here, if the court picks up the definition of notional payments in section 710, MS 1330. I'm sorry to take this at speed, but none of this ought to be controversial.
Can I just
Please.
ask you, I just want to understand what exactly the significance of this is. The Inner House affirmed the determinations appealed against, including that relating to PAYE. Now, you're addressing us on PAYE. Is this purely in relation to the alternative arguments?
Well, no, I need to make good that insofar as if the court finds that on whichever basis that one way or another, the money paid either into the trust or into the main trust onto sub-trust constitutes taxable earnings, that's no good to anybody unless there's a PAYE liability on the employer.
Yes. Yeah, but at the moment you have a determination, you have an order in your favour by the Inner House affirming the revenue's determination about PAYE. Is that not good enough for you?
I need to show the court this so that everybody is content, because it is something which I do not want, and we and those behind me don't want to squabble about after this case is finished.
So if at the end of the day we were with you on the point you're going to address us on, you'd be wanting us to make an order about this which goes beyond what was said by the Inner House.
No, the court can simply affirm the Inner House's order.
Oh, I see.
There's no difficulty there.
Okay.
That's all. No, we're very happy with the Inner House's order. Section 710, notional payments. So that's the ITEPA version of the payments made by an intermediary, which matters on the first and second alternatives. Now, I said that the regime changed slightly in 2003, but when I say slightly, it was material. If the court please takes up this divider 15, this is the 2003 PAYE regulations that apply to the ITEPA regime.
Yeah.
And whereas before we had a simple notion of employee means any old person who receives emolument, and employer means any old person who pays emoluments, here, that changes now, and there are definitions of other payee and other payer.
Yeah.
And that talks about capacity. That's different.
This is at the bottom of 1648.
Absolutely right, my lord.
Yep, okay.
MS 1648,
Yep.
my lady. I'm so sorry, I should have said.
That's all right. Yep.
And there's a case called Oriel, behind divider 32, which says that those concepts are only relevant when you've got a non-employer making a payment to an employee in a non-employee capacity.
Yeah.
Or an employer in a non-employer capacity. But it's a different extension. And that matters. Why? Because when we're looking at the analogue of Regulation 6 of the 1993 regulations, this is Regulation 21. It's MS 1655.
Yep.
So this is the payment by Rangers to the main trust. If we're right about that, the PAYE obligation on Rangers is on making a relevant payment to an employee. So this, because I can't rely on the extended definition of employer-employee for the 1993 regulations, if there was an edifice to be built on anything that the appellant says, they might have built it on this. They haven't. And they were right not to. Why not? Answer 1. Of course, the 2003 regulations have to be construed in the light of the enabling provision, which does not require payments to be made to an employee. 2, and this is why I showed the court Mr. Bain's email chain and also reminded the court of the remuneration package of the footballers. In this case, if you asked the footballers and the executives, were you paid when you were talking about the money to the trust? And this, of course, we were. The question is, what does payment mean and what does to mean? Answer, payment means all sorts of things, that's what the cases say. And in my respectful submission, it includes discharging in monetary terms, a condition of the bargain with the employee. And to an employee includes with the consent of or at the direction of. To take an obvious example, an employer who pays my train fare, if you ask me, was I paid? I'd say, of course I was.
Why? I didn't understand that. I mean, he's paid your train fare.
Yes.
Not paid you, he's paid the train fare.
And I say, my lord, in respectful response, a sensible response to that would be, of course I was paid. As it happens, the way he paid me was paid my train fare. Please, can I make that good?
I'm sorry. I think I've lost somewhere a step away. Our problem is that we've got other payers here, or potentially we might have other payers who are having to be brought within the scheme instead of the rather simple scheme we had before. And are you saying that there's nothing to require other payers to deduct?
No, I'm not saying that at all. I'm saying that the other payer, other payee regime doesn't apply in this case. But because other payers, that construct only applies when a non-employer or an employer in a non-employer capacity makes a payment to.
Yeah, but I mean, where we have the first alternative argument, the payment being made by the trust.
That would fall within other payer.
That's another payer.
Yeah, and other payee.
Is it not required to deduct?
Well, it's an intermediary. And so the PAYE obligation, because it's an intermediary, would fall on the employer. And what Oriel says, I wonder if I could answer your Lordship and then move back to Regulation 4. That might help everybody.
Is this all set out in your case? I mean, if it is, I sort of rather missed it. But
This bit isn't, because I'm doing it now.
No, I mean, can you put it on paper later then?
Yes, of course I can. And we will. But can I make a short point? And then I'll come back to your Lordship's question. I promise. If the court takes up Regulation 4, MS 1653,
One six
53, my lord.
53, sorry.
That's MS
Yes,
1653.
got it.
That tells you, if you remember, Regulation 21 talks about the employer making a relevant payment to an employee. Except payments of, so there's a specific exception, if you look at little 1, little e, of excluded pecuniary liabilities. And that's defined as payments made to a person other than an employee. So the draftsman contemplates that without that exclusion, payments made to someone else who's not the employee would otherwise be and count as a payment made to an employee. Now I'll come back and deal with my Lord Carnwath's point, that money paid to someone else with my consent and at my direction, as a matter of text, can accommodate and include the notion of a payment being made to me. And that's what the draftsman thinks. Otherwise, little 1, little e is a waste of ink. That's my short answer, my lord. That I can't face, and I don't have time to repeat my submissions of yesterday, and then the court wouldn't want me to. But it makes all the difference on my train fare example as to whether my package was my train ticket or whether my package was the payment of my train fare. That's a matter of analysis. If my employer says to me, I will pay your train fare, I don't see any difficulty at all in me saying, well, was I paid? Yes, I was. Yeah, as it happens, he paid my train fare.
The problem is simply that where we're dealing with PAYE, the test is payment. And so you're trying to find a payment, a relevant payment.
And I've got a payment.
And you're basically saying that anything that is getting the wages in some form or another to the relevant person is a payment.
Yes, and what's wrong with that?
Well, I'm not saying anything wrong with it, just a question of whether it works.
Yes.
The trouble is, I would need to get my head around this. You're saying that rather inconveniently someone changed your scheme in 2003 for reasons which we don't know, and it just makes it a little more tricky.
Yes, but the draftsman clearly thought that a payment made to someone else. Well, it's important, my lord. The draftsman clearly thought that a payment made to somebody else could count as a payment made to an employee. That's uncontroversial. And it's also the case that the regs have to be construed in the light of the enabling provisions. That's also uncontroversial. Now, that's my answer. The court may not like it, but that's my
It's just I don't really understand it, but that's simply because I haven't had a chance to get my head around it.
Well, I'm taking it at speed.
No, I know. If you don't mind, as I say, for my part, my colleagues may be quicker than me, I would need to see it in writing.
We are very happy to give an undertaking to deliver within a matter of a few days this analysis on paper.
Thank you.
But I say it could hardly be simpler. The phrase to an employee accommodates a payment made to someone else at the direction of or with the consent of an employee. That's my textual
The
proposition.
assumption, at least my innocent assumption, would be that if it's a taxable emolument, one expect it to be covered by the PAYE regulation somewhere, or something's gone
And
wrong.
that is the background assumption. That is absolutely the background assumption. That's the assumption of the draftsman of section 683, of 684, of 686, and of the regulations and of regulation 4.2.
And that's why you've taken us to them.
Absolutely.
Yeah, I'm sorry.
And that's all I'm
Thank you
saying.
very much.
That it would be a fantastically, cosmically, not even a literal construction, but a restrictive construction of the phrase to an employee. On my train fare example, and on the example of this case, the court has seen the dynamic of the payments in this case. It's not a point that the appellants have raised, but it's a point that needs to be aired so that the court can deal with it, because for the reasons I've given.
Could you, while I remember, help me on one point, which is not directly but occurred really yesterday? On page MS 208 to 209 in the Inner House's judgment, they talk about gratuities, and they say it doesn't matter whether there was a contractual entitlement, because gratuities are subject to tax, see section 62(2)(b). Now, I'm not sure whether you rely on that.
No.
I think you don't, do you?
No, I don't. This isn't a gratuity. These are wages made for good consideration.
You say these are wages.
Yes.
I mean, the problem with the gratuity is it gets you into 62(2)(b), which talks about being obtained by the employee, and then you get into that sort of difficulty.
Well, it's only a problem in the sense that I've then got to deal with what is obtained by the employee means. Yes. And again, you've got to be real world about this, in my respectful submission.
But I mean, basically, your primary position is you don't rely on that, because you say these are not gratuities, they're wages.
Absolutely.
Well, I understand that.
Yeah, absolutely right, my lord.
Thank you.
As it happens, Calvert and Wainwright, which is the case on tips, tells you that gratuities can, of course, be taxable if the source is one's employment. And the court...
yes, but they're received by the employee. There's no problem there. The potentially tricky thing is you're talking about things which are received by someone other than the employee on your primary argument.
Absolutely.
That's why the Inner House thought they had to deal with that. You say you don't need to because they're actually wages properly looked at. Is that right?
Yes, I do. I do say that. And I also say, and if I might please ask the court not to forget, that I do say that if I, as an employee, after discussion, agree, in order to avoid tax, that someone else gets my wages, or gets my... That counts as a benefit to me, if the scheme involves me accessing that benefit. Yeah. So even if I had to deal with the notion of something obtained by the employee, I wouldn't shrink from that. As it happens, I don't have to.
Thank you.
Please, may I deal with section 154? So this is if I'm wrong about everything else. And my learned friend Mr. Herbert's also wrong, and that they're real beneficiaries, all that.
Yeah.
MS 1205.
Yep.
If the court tracks the archaeology of section 154, one needs, looking at sub 2, a benefit or facility, which arises, looking at little 1, little a, by reason of employment, which is provided for the employee or other members of his family, and he hasn't made good the cost. And if there is a charge, it's the charge on the cash equivalent. That's in section 156, MS 1207, which is simply defined in little 1 as the cost of the benefit. So we say here, what's the benefit? Answer, payment by main trust trustee, sir, sub-trust trustee, at the direction of the employer. As I say, that's the FTT's, not mine, in paragraph 2 of this decision. made because and only because the employee was Rangers employee, football or executive. It was the employee's letter of wishes, the employee's loan application. It was the employee's part of his remuneration package if you're a footballer, or the discretionary bonus if you're the executive. So if that payment into the subtrust is a benefit or facility, it arises, in my respectful submission, by reason of employment, all right. And there's a cost, which is a cost to Rangers. So as a matter of principle, is that money into the subtrust a benefit or facility? Well, just on the terms of the documents, if you respect them at face value, the answer is yes, of course they must be. Why? Because quite literally, as I say, if I and my learned friend Mr. Herbert are wrong, then there are real beneficiaries. Exclusively, it's always the surviving spouse and or children. There are no charities. So collectively, looking at what actually happened, the money was tipped into the subtrust with a loan application, which collectively for the employee who wanted the loan, that's a facility all right, whether it's at interest or not. Don't care if it's not a benefit. That's a facility. And on his death, the wife and or children. So far as the wife and or children are concerned, it would be the same as an insurance policy that matured on the death of the employee. And that clearly, in my respectful submission, is a benefit. So the fact that until and unless the terms of the subtrust were changed, they had to survive the employee, that doesn't matter, it's still a benefit. Now, if all that's right, then 154 is engaged, and the payment by main trust trustee to subtrust is a chargeable benefit in kind. Is it subject to PAYE? Yes, it is, because it's treated as emoluments. 154 says one, and the corresponding provision in section 201 and 202 of ITEPA does the same, treated as earnings. And just for the purpose of the court's note, amounts treated as earnings are included in the notion of general earnings. That's in section 7 of ITEPA.
Sorry, say that again.
Amounts treated as earnings,
Yes.
by reason of ITEPA 201 and 202, etc., are treated as general earnings. That's section 7, little 1, little b, and little 4, little b of ITEPA MS 1275. There really is no need to turn that up, but...
Well, I just want to understand it. This may be my problem. 1275.
yes, my lord.
Any amount treated as earnings.
Yes.
I see. Benefits good. So, I mean, that's perfectly standard application of the benefits code, is it? That
And it's...
when you give a benefit in kind, a suit or something, then you have to deduct a sum equal to the cost of providing it.
Yes, and so far as the PAYE code is concerned, there are cases on this. Either, if the benefit in kind is in truth the sort of benefit which is cash or the equivalent of cash from which PAYE can be intelligibly deducted, then the PAYE code operates. If it's not, you need special statutory provision. This case is easy because we're talking about cash.
Anyway, as far as we're concerned, this is non-controversial, you say.
Well, I don't know if it is, but I'm giving it to you to make sure that that the case is complete. But please may I deal with what's said against me as to whether this is a benefit in the first place. The first thing that's said is that it's not capable of being enjoyed. The it here is the money tipped into the subtrust. And they make that submission by reference to a case called Templeton and Jacobs and also to Dextra. Now, Templeton and Jacobs, it's behind, and if the court does take this up, please, again, this is not going to take very long, behind divider 48, MS 2398. Now, this is the authority that the appellant relies on. But if the court sees in the head note that the case concerns the company would provide at its expense an office by means of a loft conversion, the court will see that exactly the relevance that this case has to our case, which is none. Because in that case, what was being asked was, when does a benefit in kind within Section 154 become available? Answer, when the loft conversion was completed. And if one goes to the end of the judgment at page 998, MS 2405, paragraph E, it says no benefit is provided for the purpose of Section 154 until the benefit in question becomes available to be enjoyed. So not until the loft conversion is completed. Well, fine. When we're talking about a subtrust which operates in the manner of an insurance policy for surviving wife and children, it's available and capable of being enjoyed from the minute the subtrust is created. Now, Dextra and this is at paragraphs 9 to 12 of the Special Commissioner's decision behind tab 29. MS 2043 to 2044. In that case, simply said a subtrust isn't a 154 benefit. See Templeton and Jacobs. In my respectful submission, that analysis is wrong. We're not talking about a loft conversion, we're talking about money tipped into a subtrust, which has the effect of an insurance policy. It'll fructify in the death of the employee.
Yeah.
So the short point is, do we have a benefit? Yes. Is it provided by reason, which is the subtrust? Do we have a benefit collectively for the employee and his family, wife and or children? No one else. Is it a benefit or facility? Yes. Whichever you look at, the employee or the wife and or children. Because they know that if the employee dies, they will get money. And my learned friend, Mr. Thornhill, put it like this yesterday: they're funding a family trust. Benefit or facility provided by reason of employment, capable of being enjoyed from the minute that the subtrust was created, subject to PAYE. There's no difficulty there. But that is if and only if I'm wrong about everything else.
This to the point, the inner house refused you permission to appeal today.
Yes.
Because they thought it unarguable.
I don't know why they. No, I don't know why they refused permission.
That's the normal reason.
I wasn't actually in this case, as the court well knows, until the inner house, until before the inner house. So
Anyway, you think it's eminently arguable.
well, I've just argued it, and I think I'm right, but only if I'm wrong about everything else. And I don't need any documents. I don't need any facts other than what the court has got.
Understand?
Please may the court give me one moment.
Of course.
Those are my submissions.
Thank you very much indeed, Mr. Gash. So, Mr. Thornhill, who are we hearing from next? Mr. Dunlop.
Indeed so.
Fine.
Lords, my lady, I respond to the submissions advanced by my learned friend Mr. Herbert.
Right.
In my submission, the cross-appeal which he advances is unfounded and should be rejected.
Thank you.
The starting point here is to recall the Garforth test, which is uncontroversial. Garforth, without asking the court to turn it up, is tab 24 of volume 2. The test is unreservedly at the disposal of the employee. And when we look at what Mr. Justice Walton went on to say, the question was, can the employee do with the money what he likes? Now, given the findings in fact, which the Revenue very much seeks to elide, that we are dealing here with genuine trusts, run by genuine trustees, exercising a genuine discretion, the employee couldn't do with the money what he liked, unless, my learned friend is correct to say, that the power of amendment given to protectors is such as to give him the unfettered ability to seize the assets. Now, my learned friend makes various observations which are either implicitly or sometimes explicitly critical of the subtrusts. Great submissions to make before the first-tier tribunal, which was assessing the facts. Of no moment before this court, given the findings in fact, and I'll take the court to them.
Well, he was quite careful to say he was basing it on the interpretation of the documents rather than any findings of fact, but implicitly, I think, accepting the point you make, that the necessary findings of fact weren't there, and therefore he had to take his stand on interpretation.
Absolutely. And when we look at those findings, that we have genuine legal events with genuine legal consequences, he can say this is curious all he likes. It doesn't work. Because you still have to have the understanding this is a genuine document. Now, there are multiple difficulties in my submission with the Revenue's case on the amendment. We have set out in our written case a full submission which I adopt and which I won't go through. I have I think an hour to respond, and in that hour I would plan to make 7 points in amplification of what we say in our written case. The first of those is to look at powers of amendment in general. So before we actually get to the specific text of the power of amendment here, can we just bear in mind what powers of amendment are there for and what their restriction is? This is addressed in Lewin. It's the current edition of Lewin, which is tab 68 of volume 4.
Page 2886, yeah.
And the MS number is 2901 if we wish to go directly to the passage I'm looking at.
Yep.
So this is Lewin 19th edition 30-074. A power of amendment must, like other limited powers, be used only for the purpose for which it was given. It may be expressly confined in some way. For example, it may be restricted to amendments which do not materially prejudice the interests of beneficiaries. One might do that, for example, by saying it's a fiduciary power. And a power to change the proper law of settlement is often accompanied by a power to make such amendments, and only such amendments, as are necessary or desirable to cause it to comply with the new proper law. Otherwise, its use must be confined to such amendments as can reasonably be considered to have been within the contemplation of parties when the trust instrument was made, having regard to its nature and circumstances. And then this crucial sentence. Another way of expressing the point is that an amendment must not change the whole substratum of the trust or its basic purpose. That said, under reference, as we see at footnote 222, to the advice of the Privy Council given by Lord Walker of Gestingthorpe in the Bank of New Zealand case.
Yeah.
Now, in my submission, the amendment which the Revenue asks the court to contemplate is one which would take an 80-year trust with powers of accumulation for the benefit of family members, in which the protector is himself expressly and presumably deliberately excluded from the beneficial class, and turn it into an immediate payday by excluding all of the beneficiaries, inserting the protector in their stead, winding up the entire structure and seizing the assets. One could not get a clearer example of something that alters or subverts the whole substratum of the trust or its basic purpose. That is not what this amendment is for. Now, the Revenue seeks to bolster its submission by saying, well, there must have been a contemplation that one might want to add beneficiaries, for example, to add a new child. Well, the problem with this case, in which the Revenue asked the court to deal with this in the round, we've got 108 different subtrusts with many different ways of expressing the beneficial class. And the difficulty with that submission is best illustrated if we look at another of the trusts, that of Tommy McLean, MS 746. That's Appendix Part 1, tab 26. Yep. And we see there, MS 746 at the foot of that page, that for Mr. McLean's subtrust, the principal beneficiaries are defined as meaning the widow, children and remoter descendants of Thomas McLean who shall be living at his death.
Yes.
So in that situation, there isn't any need to amend that to add in children because children are covered. No need to add divorce because that's covered. And also, what the court will note, and the remoter descendants of Tommy McLean. So while we're on that, that also answers my learned friend's point on why does one need the protector's consent under clause 2.2? Why? Because my learned friend says, well, if there are no beneficiaries, there are no beneficiaries. Well, there might well be a dispute about whether or not there are remoter descendants. Could be a dispute about whether or not there are children. My learned friend also says, well, there isn't really a trust here because the beneficiaries don't become beneficiaries until the death. Well, again, that's not right. A contingent beneficiary is enough for a trust to exist, especially where power of accumulation exists. But if he was right, if there's no beneficiaries, then there's no trust. Then the subtrust is utterly vacant. It doesn't do anything. So the money's still in the main trust, and the power of the employee to act as protector doesn't exist. So if he's right in that, he destroys his entire case.
So, looking at in the deed you've just asked us to look at clause 2 on page 747,
Yes.
we're told that the trustees are to hold the trust fund and the income upon trust for all or any one or more of the principal beneficiaries in such shares, etc., as the trustees shall appoint. And in default of any of them, this one's different again, I think, from Mr.
Yes.
Bain's trust, isn't it? We have a default provision.
Yes.
In default of any appointment, shall so hold upon trust for the beneficiaries on the terms of a deed establishing a principal scheme.
Yes.
So you would say this one sorts the problem that might have, well, that this one addresses the issue that arises under clause 4.1 of Mr. Bain's trust.
Yeah. Well, I say there isn't a problem because following the logic, there are two possibilities. Either there's a trust with contingent beneficiaries, which is what I say there is, or there's no trust at all because there are no beneficiaries, because there hasn't been an appointment, in which case there hasn't been any subtrust at all. It's completely, nothing to the point, it's completely nullified, in which case the money is still in the main trust. There's no power on the part of the employee as protector, and he doesn't have it unreservedly at his disposal. On either of these bases, the argument doesn't work. But coming back to the revenues argument, well, it must be possible to amend in new beneficiaries. Well, that's, okay, let's assume that they're right in that. An amendment to add new beneficiaries might well be consistent with the purpose of the trust and therefore not be such as to subvert the purpose of the trust. Per contra, an amendment which says, beneficiaries, you are gone, I am now in your stead, I am appointing all the capital to me with no other possibility of anyone else, and invoking Saunders and Vautier to wind this up. You can't get a clearer version of subverting the purpose of the trust. So that's point one, and frankly, point one could rest my submissions, because it simply won't do for the revenue to run this. And it kills the submission instantly. But move on. Second point is the importance of context, because the revenues argument in this regard starts with saying, let's look at the textual analysis. Well, textual analysis is not, as this court well knows, the be-all and the end-all. The construction of subtrusts, as with any utterance, needs to be done against the factual background. Now, that I assume is trite. It was explicated in the Metoy case, if the court needs it, original pages 1610 and 1614. And considering the trusts against the factual background was the job of the first-tier tribunal. And it has made various findings, in fact, which are inimical to the submission that is now made by the revenue. By way of example, if we go to the first-tier tribunal, please, in the appendix.
Yes.
Which
page do you want to go of it?
MS 283, please, my lord.
Thank you. Yep.
103 is the findings in fact.
Yep.
Roman numeral 5.
Thank you.
When the possibility of creating a subtrust in the name of an employee was contemplated, the benefits and trust mechanism would be explained to him, viz. The loan facility providing a tax-free sum greater than payment net of tax deducted under PAYE and repayable out of his estate, so reducing its value for inheritance tax purposes. Further, the employee could also be appointed protector with extended powers in respects resembling trusteeship, but without title to the trust estate and not enabling the conferring of any absolute beneficial right on the employee himself. Likewise, if we move on, MS 305.
Yep.
Paragraph 193, last 3 lines.
Yep.
The FTT is contemplating enforceable legal structures in place which are of fundamental practical effect and not merely incidental or artificial for tax avoidance purposes only. MS 316.
Yep.
Paragraph 223. In our view, in the present appeal, we have to regard the trust structure and the loans as genuine legal events with real legal effect. And over the page at 232, after the first sentence, they reject the submission made by the revenue. They say, we are unable to make further findings, in fact, in support of there being an orchestrated scheme extending to the payment, in effect, of wages or salary absolutely and unreservedly to the employees involved, as Mr. Thompson, that was counsel for the revenue, urged us to do. We considered this with some care in view of his trenchant criticism of certain witnesses' evidence.
But I think this is all based on the evidence, whereas, as I say, Mr. Herbert's submission is based on the accepting, really, what's said in 223, but saying that when you construe it, the document, you get the result for which he argues.
He did, although part of his submission in that regard was to look at Mrs. Orchard's evidence.
Quite.
Mrs. Orchard's evidence was discounted as being completely unsatisfactory, paragraphs 85 and 86 of the FTT. So why are we looking at that?
I see the force of that, but in the end, he takes it, as I say, rightly or wrongly, that's his submission.
Yes, and as my closing point then on point 2, the context. Part of the context here, picking up on something that fell from my Lord the President earlier, the whole purpose of this document is to create a structure which is tax efficient. And yet, that being on any view part of the context, the revenue says, well, you have to construe it in such a way that makes it an immediate emolument. Well, that seems a rather startling proposition. Point 3 is this question of fiduciary restrictions. Now, the revenue asks, now not all of the deeds say that the power to amend is fiduciary, but for those that do, the revenue asks that this court simply ignores that word. Now, in my submission, a stipulation that the power of amendment is a fiduciary one, it makes that point simply unarguable. The court cannot simply ignore it.
I think he says that fiduciary, almost is slightly unfair caricature of his submission, but fiduciary can mean non-fiduciary.
Yes.
Look at metoi category 1.
Well, I'm coming on. Let's coming on.
See the point that says one
yes.
can't just cross it out.
Yes, I'm coming to in a second to metoi category 1, but sticking for the moment with metoi category 2, that is surely what is meant when one stipulates that a power is fiduciary. And the best you can do in order to discount that is to say, well, look, when it stipulates the Baxendale Walker fees, that's described as fiduciary, that must be wrong. Quite accept that. But equally, paragraph 7.1, when it goes on to give the power to appoint new trustees, it says that's fiduciary. And we all agree that that must be right. So we have one instance of it being used correctly and one instance of it being used wrongly. And in a situation where it makes perfect sense to stipulate the power as fiduciary, Mullin and Friend says, well, it must be wrong. What principle of construction or of interpretation is it that he invokes here? It is no more than that of Humpty Dumpty. Words mean what I want them to mean, no more and no less.
Words mean what I don't want them to mean, so I'm going to strike them out.
Indeed so.
Yep, okay.
So, where the trusts don't so provide, in my submission, the reasoning of the Inner House, which is full and correct, is to be commended to this court.
Right.
In general, powers exercised by a protector are fiduciary powers, and I commend to the court, without asking them to read it at this point, the comments of Underhill and Hayton in the textbook found at Authorities Volume 4, tab 70, MS 2910.
Thank you.
That was what commended itself to the Inner House.
Yes.
The chapters are 1.78 to 1.80 in the text.
Thank you.
And what they say, the general rule is that a fiduciary should be, a protector is exercising his powers in a fiduciary fashion. And that makes perfect sense, because as a matter of generality, fiduciary powers fall on somebody who is acting to protect the interests of another. Well, accepting that the revenue are entitled to say, we can't ask the court to decide it solely on the basis of titles, the word protector is nonetheless not one that you can simply ignore out of hand, and I would suggest that the clue is very much in the title. Now, the restrictions explained in Underhill, if it's a fiduciary power in the fullest sense, means that the protector simply can't do what is presently under contemplation. That would be the clearest breach of a fiduciary obligation. Let's say I'm wrong about that, and that what we are talking about here is a category 1 metoi, and the other description that's used to describe a category 1 metoi is a limited power. That's the way the revenue puts it in their case at paragraph 86. So if it's a limited power, can this be done? Well, If we look, please, to the current edition of Lewin again, Volume 4, tab 68, MS 2891. Yes, MS 2891, and it is paragraph 29-017. The authors discuss the exercise of limited powers, and this is what the revenue says that the power of amendment is. Limited or restricted powers must be exercised in good faith for the purposes for which they were given, which in these cases is restricted. They differ from beneficial powers in that they are conferred for the benefit of one or more beneficiaries other than the donee. A special power of appointment is an example, being a power to appoint a beneficial interest to a given beneficiary or one or more of a class of beneficiaries. The constraints on the exercise of a limited power are expressed in the doctrine of a fraud on the power. An exercise of the power can be impeached if, 1, it was made for a corrupt purpose, such as the benefit of the donee himself. Now, what the revenue is contemplating here can only be described as something that is being exercised for the benefit of the donee himself. So even if it's a limited power, and not a fiduciary power in the fullest sense, he can't do what the revenue says he could. And that is supported, and again, simply for the court's reference, by the two Jersey cases. They're Centre Trustees, Volume 3, tab 58, MS 2616-7, and the Internine case, Authority 3, tab 53, MS 2517, paragraphs 53 to 55.
Thank you.
In both of those cases, the Royal Court held that the protector couldn't simply act in his own benefit. And in the first of them, Centre Trustees, when the court looks at it, they will see that the power of amendment in that case was expressly stated not to be fiduciary. And yet, Mr. Pabst, when he acted in the way that he did in his own interest, was held to account by the court, and rightly so.
Yep.
The fourth point, then, is the need for consent. And the court recalls that the power of amendment is subject to the requirement for the consent of the trustees where their interests would be adversely affected. And if we need to look back to that text, if we use the Bain Subtrust, for example, it's MS 552. It's at the end of 9.1, provided that the foregoing power shall not, without the consent in writing of the trustee, be exercisable in any manner which would adversely affect the trustee. Now, the difficulty with the Revenue's argument in this regard is that it asks the court to determine, ab ante and shorn of any context, that there can be no circumstances in which what is contemplated would ever be to the detriment of the trustee. And in my submission, it isn't difficult to envisage scenarios in which the amendment would adversely affect the interests of the trustee here. As the court has seen from the statement of facts and issues, what happened here was, as soon as the money was devolved to the subtrust, it was onwards lent by way of an interest-bearing loan to the employee. Accordingly, when the ex hypothesi arising tax bill lands on the desk sometime later, there are no assets with which to pay it. Now, clause 10.1 very clearly requires the trustee to cover that tax bill, and it doesn't work for the Revenue to say, well, that's fine, because there's then a right of indemnity against the employee, either under reference to the deed or at common law, What happens, because the revenue need to be able to say this can never, ever, ever be prejudicial, what happens if the footballer's lost all his money? Which does happen from time to time with professional sportsmen. So we can say that there is a non-theoretical possibility that it would adversely affect the interests of the trustee. And that being so, you can't say now, ab ante and shorn of context, that it would never be prejudicial to the interests of the trustee to allow this amendment to proceed. So that's the fourth point. Right. The fifth point is the question of entrenchment, because the power to amend very clearly entrenches certain aspects of the subtrust. And if the court still has open the Bain subtrust at MS 552, we see that that entrenchment is done by way of 9.2, which says that the power to amend shall not be exercisable nor exercised to alter any of the provisions of Clause 2, Clause 3.3 I don't need to bother the court with, or to alter any of the provisions of Clause 10.1 below. Well, the fifth point rather deals with Clause 2, and Clause 2 is the declaration of trust. These provisions are entrenched and cannot be altered, but the revenue's argument is that that entrenchment actually means nothing, because one can amend Clause 2 by the side wind of altering definitions in Clause 1. This is also an argument that should be given no credit. The declaration, if we turn back to it, Clause 2 is found at MS 549. Clause 2 uses various phrases which have been the subject of definitions in Clause 1. So I assume that the revenue's argument means one can change the definitions of any of these. So on that argument, one assumes, for example, the definition of trustee. We go back to that. It's defined at 1.1.1 as meaning the original trustee, or other trustees or trustee for the time being hereof. On the revenue's argument, you just amend 1.1.1 to say the trustee means the employee. There we go. And in that way, bearing in mind that the power of appointing new trustees at 7.1 is expressly declared to be fiduciary, so the protector cannot, under 7.1, appoint himself as trustee. Here, by the simple expedient of amending 1.1.1, he sidesteps that fiduciary duty and he amends the whole point of the declaration of trust in Clause 2. He could also, one assumes, amend the trust period. So it's meant to be an 80-year trust. Change it into an 80-day one, I guess, on this argument. He can amend the trust fund, which is defined as meaning all of the assets held. Just amend that to a fixed sum of money. And apparently, he can amend principal beneficiaries by saying, I'm sorry, family members, I know you were entitled to expect that I as a protector look after your interests, but no, you are all gone, I am in your stead and I'm having all of the money. None of these amendments would in any way respect the meaning of Clause 2 as entrenched. That means that the amendments are simply not legitimate. The revenue's case, neither in writing nor orally, gets nowhere close to beginning to explain the basis upon which such amendments would be consistent with the entrenchment of Clause 2. The revenue's argument in truth founders on the restrictions of powers of amendment in general, but then when we come to look at the specifics here, the case just falls away. Point 6 is another entrenchment point, because if we go back to Clause 9.1, or rather Clause 9.2, we see that the other entrenchment is that one cannot alter Clause 10.1. 10.1, irrevocable limitations on trustees' powers and protectors' powers. Notwithstanding anything to the contrary, express or implied in this deed, no power or discretion hereby or by law conferred on the trustee or the protector shall, notwithstanding anything to the contrary herein expressed or implied, be exercisable in such manner as to cause any part of the trust fund or the income thereof to be used to provide a prohibited benefit. Prohibited benefit. Now, this is discounted by the revenue in the written case. They say, well, this is just putting aside any question of there being pensions payable. Well, that's not quite correct, because if we go back to prohibited benefits, they're defined, starts right at the foot of 548 and over to 549, 1.1.5.1, 2, 3 and 4. Now 1, 3 and 4 are all looking at pensions. But 1.1.5.2, any sum or benefit which, were it to be received by a principal beneficiary, would constitute for the purposes of income tax an emolument of any person formerly employed by or holding office with the founder. So, again, picking up on an earlier observation, the whole point of this document is to avoid there being emoluments, and emoluments are prohibited benefits. Now, 10.1 is entrenched. You can't derogate from 10.1 to allow payment of prohibited benefits, so you can't have payments of emoluments, which rather goes against the proposition that this deed should be considered as effectively conferring an emolument. I suppose, again, the revenues case would be, well, you can just amend prohibited benefits and say instead of prohibiting emolument, you could prohibit the giving of birthday presents. Well, in that situation, we are through the looking glass. The final point, my lady, my lords, is the question of, so this is point 7, addressing the case of Edge against Edge and the Pensions Ombudsman. Now, the court's not been taken to the case, but it's there for the proposition that if the deed says that one can self-deal, if the deed expressly authorises self-dealing, then that has to be permitted. And in Edge, what happened was there was an occupational pension scheme, and there was...
Could you give us the...
I'm sorry, my lady. Edge is MS 1971. The passage I'm looking at is 1971. It's volume 2, tab 26.
Yeah.
And it can so readily be distinguished from this case because in that case, the committee that had to make the decision necessarily had as its membership persons in the beneficial class who were going to be affected one way or the other by the decision that they made. And the Court of Appeal makes that point clear. If the court has MS 1971, just after letter E in the case, where it was said, in the present case, the rules specify the composition of the trustees. The board's trustees must be past or present members of the board, that is to say, holding or having held an office equivalent to that of director. The members' trustees must be appointed from among members in service. There is no provision in the rules for the appointment of trustees from amongst the pensioners. Yet it must have been obvious at the time when the scheme was established that the trustees would need from time to time to take decisions which required them to arrive at a balance between the interests of the employers as contributors, the members in service as contributors and beneficiaries, and the pensioners. It is inevitable that such decisions will be perceived by some to favour one interest at the expense of another. Where is the inevitability, I ask, in this subtrust that the protector will have to make decisions that favour him over the beneficiaries?
I think there was a similar argument in the matter of Z Trust.
Absolutely.
Where there was an inbuilt conflict of interest.
Absolutely. And what Mr. Justice Smelly, of course now the Chief Justice of the Cayman Islands, said was, if as a matter of necessary implication the deed authorises self-dealing, then that is what the court will permit. Where is the necessary implication, I ask, in the subtrust? One can search this document as long as one likes, and one will find many criticisms of the drafting in the document. But what one will not find at any point is an authorisation on the protector to do what the revenue says he could have done. My lords, my lady, that brings me full circle, because in my submission, when we start with the question of powers of amendment in general, and when we look then to the context of this deed in particular, and when we look to the point that you can't destroy the substratum of a trust, and when we understand the fiduciary context, the need for consent, and the entrenchment of clauses 2 and 10, all of this means that the argument advanced by the revenue here is simply untenable and must be rejected. I'm happy to address any point arising, but otherwise the court has my submission.
Thank you, Mr. Dunlop. Thank you.
Obliged.
My lords and my lady, I'm so sorry. I'm ashamed. I forgot to mention in the course of my submissions that Mr. Thornhill had made a point about the relationship between 154 and 160 in priority. I've got nothing to add to this, that's all. I just wanted to address that for the record.
Which paragraph? Just
141, little 2.
Thank you very much.
I'm so sorry, I should have said that.
No, thank you very much. Very fair. Thank you.
May I begin, my lord, by replying to the points made by my learned friend Mr. Ghosh yesterday, that is to say, on the question of earnings or emoluments. In my submission, his case has veered between two different propositions. One proposition starts with the question, what was the real bargain between the employer and the employees? And then he goes on to develop what he says that bargain was, and which we submit is entirely contrary to the findings of fact. I'll come back to that in a minute. But the second approach is what I perhaps could describe as the source approach, which doesn't really concentrate on the bargain. It simply says, if money results, a payment of money results from the performance by the employee of its services, it doesn't matter who it's paid to, it can be earnings or emoluments. Now that is, in my respectful submission, a different argument. It's the argument which really found favour before the inner house. But could I return first to the question of what was the bargain between the parties? Could one start with the executives and their bonuses? Yeah. I don't need to remind the court of paragraph 205 of the first tier tribunal's decision. I've referred to it more than once, and it's been referred to by others. That was the paragraph which said there was no contractual right whatsoever. It was simply a question of the employer deciding, admittedly with consultation with the employee, on providing a discretionary bonus in a particular form. And there's nothing we would submit to construe there, because your lordship will recall there's nothing in writing. That was the whole point of the finding in paragraph 205. And so one can't, in my respectful submission, go behind paragraph 205 and say, I know what the real agreement was. It was an agreement to pay wages in two forms, and one form was satisfied by the payment to the trust. That is to wholly subvert the finding of the first tier tribunal, who, I can only remind the court, listened to evidence for 17 days and had to concentrate, as is made clear in paragraph 232 very hard on the evidence to decide precisely what were the transactions and what, if anything, had been agreed. It's quite wrong in my submission to sideline those findings based on 17 days of evidence. And in effect, because this is what it really amounts to, say, well, actually, Dr. Poon was right. Dr. Poon, see, I don't really need to read it out, paragraph 195 of her decision says, I can remove the camouflage, I know what the real bargain was. Well, that's precisely what my learned friend is saying. So I say it's a complete subversion of the first-tier tribunal's findings. There wasn't any antecedent contract of the type he describes. He did in that context refer the court to the last page of Appendix 2. I can just take it, I'll find the MS number. It's MS 1157. And in clause 2 of the minutes there's reference to a constructive obligation that was pointed out to the court. The inference being, as I see it, that obligation meant there was a liability. But I would urge the court to take no notice of that. The term constructive obligation is a term of art in accountancy. It means an obligation which is less than a legal obligation. It could be an obligation simply resulting from an assurance given by an employer to an employee without any legal obligation at all. Now, coming to the case of the footballers and pursuing this, what was the real contract argument, the way my learned friend puts it is, well, it's obvious what the real bargain was. It's wholly unrealistic to think that what the players agreed for was the mere hope that they might get a loan from the sub-trust. Well, of course, that's a rather pejorative way of describing what was on offer. If one looks, and again, I don't think I need refer to it, at paragraph 103 of the first tier decision, at little Roman 5, you see it was read out, I think, by one of my learned friends this morning. You can see that it was carefully explained to the persons, the employees, what it was they were getting. And one could describe it, I suppose, as the creation of a trust fund, principally for the benefit of chosen beneficiaries chosen by the employee, with the possibility, a very real possibility, that loans could be obtained from it.
Is that formulation helpful to you? It was the creation of the trust fund.
Well, I do apologise. My hearing is getting very
sorry, no,
bad.
it's my fault. It's my fault.
No,
I wonder. I'm sorry. Don't apologise. It's my fault.
Well, it's probably mine as well. But
well,
there we are.
We won't argue about that. I was going to wonder whether your formulation is helpful to you. If the consideration, as it were, was the creation of the trust fund, isn't that quite a helpful way for the revenue to put it? I'm saying, isn't that quite a helpful way from the revenue's point of view?
What to say that?
To say that it was the creation of the trust fund is what they were being offered.
It may be helpful, but I mean, we would say yes, if it was the creation of a fund, but if you like, what the employee got was the creation of the fund with all its attendant benefits. That's not money or money's worth, and so it isn't earnings or emoluments.
Thank you.
It's as simple as that, we say. Of course, putting it that way would immediately make your lordship ask, well, why isn't it a benefit in kind? But I'm coming on to that later on, so
Understand.
I'll keep that back. In other words, really, what I say, it's perfectly clear that the first tier tribunal, and Lord Doherty agreed with them,
Yeah.
that there wasn't any agreement to pay wages, which was then diverted into a trust fund. What was on offer was the creation of the trust fund with its various attendant advantages. That's what the employee got. It's not earnings or emoluments, and that's the simple answer to the problem, we say.
Thank you.
Of course, if there were an agreement that there would be a payment of earnings which was going to be satisfied by creating the trust, we would accept that what one might call the Smith and Stretton principle would apply. If you've got the right to the earnings and you then agree that the earnings are applied in creating the trust fund, that would seem to be very much in line with Smith and Stretton. But as I pointed out to your lordship, and I think it's reasonably clear, in Smith and Stretton there was a clear right to the salary coupled with an agreement to apply it in a particular way, and there wasn't such an agreement, we submit, on the clear findings of the tribunal in this case. So what I might call the real contract between the parties way of putting the Crown's case is, in my view and in my submission, an impossible one, given the findings of the first-tier tribunal. And may I emphasize the point that respect must be shown to that tribunal, who sat through trenchant cross-examination for a very long period of time. The whole object of that cross-examination, I think one could fairly say, was to uncover some tacit agreement which wasn't on the face of it in the papers. Now, the other way in which my learned friend puts it is what I call the source argument. Ask yourself, and this is how the Inner House approached it, was the money payment which went to the principal trust the fruit of the employee's work? Was it, in other words, using the old-fashioned language, an emolument from the employment? Therefrom is the operative word.
Yes.
No one disputes that. Of course, this arrangement was there to reward employees. That's perfectly obvious. And no one, in my submission, in their right mind, could possibly maintain the contrary for any length of time. But that's not the point. The point is what the employee got an emolument, or, in the new language, earnings. If the point is put as widely as my learned friend puts it, it would be apparent in my submission, and I'll make this clear later when we come to benefits in kind, that virtually every benefit in kind, or certainly many of them, would become earnings or emoluments, because, as your lordship has already seen, the key concept in the benefit in kind legislation is the incurring of expense in providing a benefit. Well, the most obvious way to incur expense is to pay money. So there will be a money payment, and then my learned friend will say, aha, what is the source of this payment? It is work done by the employee, therefore it's earnings or emoluments. His case, in my submission, elides the two in a wholly impossible way.
Yes, I see.
With that in mind, could I take the tribunal now to Ford and McHugh, about which there have been considerable discussion. This is volume 2 of the authorities,
Yes.
number 33 or MS 2111.
Thank you. Yes. Yes. Yes.
First point I'd like to address on this case is the point which arose in argument with my learned friend when, I think it was my Lord Carnworth, said, well, did the revenue miss a trick? Well, actually, they didn't miss a trick, as it happens, because at the relevant time, there was a special tax charge on monies paid by employers to unapproved retirement benefit schemes. And if one went to it's not in the authorities, I'm afraid, to the upper tier tribunal decision in the Ford case, it's quite clear that there was actually an actual tax charge under what was then Section 595 of the Income and Corporation Taxes Act, 1988. At this late stage in the appeal, I don't want to labour your lordship with too many authorities. That section became Section 386 of ITEPA, but it ceased to have effect, as I recall, in about 2006.
Right.
So the position with payments to unapproved schemes for income tax purposes is that there was at one time a special charge on monies paid to them. What, it might be asked, was the position under the, so to speak, general law of tax on earnings and emoluments. That can be seen if one goes to ICTA 1988.
Right.
If I take you to
Yes.
Section 154,
That's 1205, yep.
which you've seen,
Yep.
and
Page 1205.
sorry, 154, as your lordship will recall, MS 1205,
You wanted its original.
is the one which poses the charge on
Yes.
the provision of benefits.
That's right.
And then, if I'm afraid you have to take into your hands the little black bundle,
Right. We're looking at 155, are we?
and you go to 155, your lordship is ahead of me at the moment, and we find that there is
Yep.
an exception for pension provisions. It's 1554 on divider 1 of the little black volume.
Any pension, annuity, lump sum or the like. Yes, I see.
And that says clearly it doesn't apply, Section 154 doesn't apply to a benefit consisting of provision by the employee's employer for the employee himself or spouse, children, etc.
Sorry, which I'm being a bit slow.
155 subsection 4.
155 subsection 4, my lord.
Thank you.
It expressly takes out
Yeah.
pensions, and there is a similar exemption in section 307 subsection 2 of ITEPA. I don't really see the need perhaps to refer your lordships to that, but it's there.
Thank you.
And the position of payments to unapproved pension schemes was, first, there was a charge at one stage. That charge disappeared in 2006. Then the exemption from the benefit in kind charge took over. And what I would submit to the court is this: it's quite clear that it would be utterly pointless to have an exemption from the benefit in kind charge if a payment to an unapproved pension scheme was otherwise an emolument or earnings. Because if it were emolument or earnings anyhow, there'd be absolutely no point in exempting it from the benefit in kind charge. But the position in our submission is that a payment by an employer to an unapproved pension arrangement is not earnings or emoluments, because you look at what the employee gets, which is the benefit usually of a non-assignable pension. Therefore, it's not money or money's worth. They have a value to him, but it's not money or money's worth. And that would then bring the treatment for income tax purposes entirely into line with the treatment for national insurance purposes, which was the subject matter of the decision in Ford and McHugh. Of course, there's no necessary reason why the two should be brought into line, but it would be very peculiar in my submission if, for income tax purposes, it was earnings or an emolument, but not for NIC purposes, for the very good reason, as Ford and McHugh makes clear, that the NIC concept of earnings goes wider than the concept of earnings or emoluments.
Yes.
And that, in my respectful submission, shows where the Crown's argument is going wrong.
In paragraph 17 of Ford and McHugh, where Lord Hodge talks about what's implied in the term earnings of something obtained by the employee, you would say that applies also to the concept of emoluments.
My Lord, yes, I do. You see, this goes back to a point that your Lordship has raised about section 62.2. Why does it go out of its way in 2B to talk about gratuities, etc., obtained by the employee? And it doesn't say salaries, wages, etc., obtained by the employee. The answer in my submission is that it's inherent in salaries, wages, etc., just as it was found to be in Ford and McHugh, that you're obviously looking at the employee because he's the person that earns the salary or wages. Now, in relation to 62.2b, there is some history, because your Lordship will recall that the purpose of 62.2b was to provide a substitute definition for what were perquisites in the old legislation. My learned friend did refer to a case called Pook and Owen.
Yes.
Now, Pook and Owen was very interesting in this regard, because the revenues case in Pook and Owen was that although generally Schedule E, as it was then, was a tax on money or money's worth, that did not apply to perquisites. That was the whole point of the revenues argument in Pook and Owen. And one can well see that the draftsman of Section 62 wanted to sort of ram that point home by making it clear that perquisites, just as salaries, etc., had to be something obtained by the employee as opposed to anyone else. That is a guess. I don't know that that is correct, but...
Does that apply to C as well, profits or other...
Yes, well, C, I mean, certainly the draftsman of Section 62 seems to be saying, look, I'm putting in C just in case I've missed something out. But yes, I would submit it will be very peculiar if obtained by the employee applied to the first two, that it didn't apply to the third. Mm-hmm. Now, staying, if I might, on Ford and McHugh, and going back to your Lordship's point about had the revenue missed a trick. Well, they hadn't in my submission, because if one goes, it's MS 2106, if one goes to paragraph 15, and to see what the revenue argued, just below, between the letters E and F, we have this. The revenue looked to the payment and not to what the earner received. The revenue argued that the payment into the trust fund was earnings because it was a sum paid as the quid pro quo for past or future services. It was part of Mr. McHugh's remuneration. So they didn't miss a trick. I mean, that's precisely the point which is being put by my learned friend. So the point was fully in the court's mind, but for the reasons which we've already looked at, the court said, no, despite the fact that it was a quid pro quo for services, in other words, despite the fact that the source of the payment was the employment, it wasn't earnings for NIC purposes. And no more should it be, in my submission, for income tax purposes. In that context, your Lordship may recall my learned friend referred to section 308, which exempted from earnings payments to certain pension schemes. Now, he relied on that for the opposite proposition. Fair enough. He said, look, what on earth is the point of section 308 if a payment to a pension scheme isn't earnings or emoluments? The whole point of section 308 is to exempt it. In my submission, that's wrong. There are actually several provisions dealing with exemption from tax for various pension scheme contributions. This particular one, I believe, came in 1970, in the Finance Act 1970, when something called personal pension schemes came in for the first time. What one might ask was the point behind section 308. In my submission, it was either out of abundance of caution to make it clear, or possibly the draftsman meant that even if you were caught by Smith and Stretton and you had a right to salary, but instead directed it to be paid into a personal pension scheme, that you didn't suffer tax under Schedule E on emoluments or tax on earnings. It may have been, that may be the purpose. But in my respectful submission, section 308 can't be used the other way round to argue that a payment into a pension scheme is an emolument or earning. The contrary position is, in my submission, the correct one. If your Lordship would like the reference to the Ford and McHugh in the upper tier tribunal, it's Simon's tax cases for 2011 at page 1428.
Thank you. Yeah.
Next, my lord, I come to Edwards and Roberts. Your Lordship remembers the facts that these payments were made for 5 years from profits of the company. Yep. They went into the conditional fund, and Mr. Yep. Roberts got it at the end of 5 years. And it was held to be an emolument of the 5th year.
That's right.
Now, I asked, so to speak rhetorically, well, if the Crown are right in their submission, why weren't the payments each year made to the conditional fund earnings or emoluments? Because they were part of the package, employment package, which Mr. Roberts enjoyed. They were clearly meant to incentivize him, so they were a reward from work. So the source was clearly the payment, the source was the work done. There was, of course, no agreement that he should be paid this sum as wages. He had another wage, £425 a year, that was the wage. But ignoring that, the payments, which were put into the conditional fund, had, I would submit, all the hallmarks of earnings or emoluments contended for by the Crown. But yet it was held that they were not. Now, my learned friend, I think, said, but there was some uncertainty in the amount of these payments. In other words, they were paid out of profits, if there were any profits of the company. But that surely can't make any difference. Ultimately, they were quantified and the payments were made. When they were made, you knew what the amount was. And that amount fulfilled all the requirements put forward by my learned friend under his source argument, but they were not held to be assessable. And the answer, in my respectful submission, is the simple one. It goes back to Heaton and Bell. You had to ask, what was Mr. Roberts' entitlement? He didn't have any entitlement to receive these payments. He only had the chance of getting the fund after 5 years. So the Heaton and Bell test satisfies the result in Edwards and Roberts, but my learned friend's test fails it, in my submission. And I've already, I think, made it clear that in our respectful submission, the inner house failed to offer any real grounds for distinguishing Edwards and Roberts. You remember they said the trustees became entitled to the payments. Well, that's neither here nor there. We're looking at the employee, not the trustees. So on Edwards and Roberts, we say it's entirely in line with Heaton and Bell and is explained by it. So what we call the causal or source test, which my learned friend puts forward, is wrong. The entitlement test is right. Coming on next to the overlap between emoluments or earnings on the one hand and benefits in kind on the other. Probably your lordship has my point, which is very simple. The benefit in kind legislation depends on someone, not necessarily the employer, incurring expense on providing a benefit. And then the measure of the benefit in kind charge is the cost expended by the employer. The benefit has to be from the employment, that's clearly spelled out, and in fairness, it has to be by reason of the employment. I'm sorry, that's the actual words, by reason of the employment. There is some authority, I think it's Wicks and Firth, which suggests that the by reason of test isn't quite so strong as the therefrom test with emoluments. But obviously, there's a source issue. The employment has got to be the source of the benefit. Well, what we say, well, as soon as you look at the benefit in kind charge and you see that it rests on the costs incurred in providing the benefit, the costs incurred will nearly always be an expenditure of money, and therefore, on the learned friend's approach, virtually every benefit in kind becomes turned into earnings or emoluments. That, I suppose, is possible, but it's highly unlikely, I would respectfully admit. Now, my lord, would it be sensible to stop at this point? I have a few more points. I can't finish them in 5 minutes because I've got to do benefits in kind.
How much longer do you think you'll be?
I'd probably get it down to about half an hour.
I think it would be, particularly as we started at 10, it would be more sensible to resume again at 2 o'clock. And so particularly as we started at 10, I think it would be more sensible to resume at 2 o'clock.
Yes.
And also, my experience suggests that if one gives time to reflect, it probably shortens rather than lengthens the mission.
Yeah, very well, my lord.
So we'll resume again at 2 o'clock.
2 o'clock.
Thank you very much. The court's now adjourned.